You ever hear somebody say, I'm going to sue somebody in the Supreme Court? You ever wonder what that really means or how it actually works? Well, the plan for this video is to go through the procedure of how the actual Supreme Court operates. It's fairly short in terms of number of slides, but it has some very important information. Please make sure you're taking notes as I go through this. You'll be expected to understand all of this and be able to answer questions on a test about Supreme Court procedure. Okay, first of all, we're assuming your case, we're talking about the 99.9% of cases where the Supreme Court has appellate jurisdiction, which means the case starts at the district level or at a state Supreme Court level and then is appealed to the Supreme Court. There are a few exceptions where cases start in the Supreme Court, so those are very rare cases. And in which case they have a completely different procedure for those anyway. If, for example, you feel like you are wrongly accused and found guilty and have appealed and lost your appeal and feel like is now your chance to get justice in the Supreme Court, you petition the court for what is referred to as a writ of certiorari. Certiorari is a Latin legal term for reviewing the case. They do charge you a filing fee of about $300 a year, which basically covers photocopying expenses. People who can prove that this is too expensive for them can fill out a separate form and have the $300 fee waived. There are thousands of petitions that are sent to the court every year. Probably about half of them are relatively bogus petitions by federal prisoners who have frankly nothing better to do while sitting in their jail cell but write petitions to the court claiming all kinds of ridiculous things like cruel and unusual punishment, violation of the Eighth Amendment because their food was served cold or whatever. But probably about 4,000 serious petitions to the court a year asking for review of state law, federal law, and other important concepts that need to be reviewed. The court gets to choose which cases it reviews. Each judge has 3 or 4 clerks. These are people that work for the justice for 1 year. They tend to be the best of the best recent law school grads who work really hard and really long hours for a year reviewing all of these petitions. And while they do have a pool of the petitions, they do circulate. Each clerk is reading probably 15 or 20 very long petitions a week on top of all the other responsibilities, and then they write a summary of the petition and give it to the justice. And the summary includes a recommendation to grant cert or to hear the case, or to not grant cert or not hear the case. Okay, at the very beginning of the year, which for them is September, justices meet for about a week and a half, and they sort through all of the petitions that have come in over the last year and decide which cases they're going to choose. There used to be more formal requirements on cases they had to hear, they didn't have a choice on, but those have been lifted. So currently the court hears about 80 to 100 cases a year. They feel like it's more important to do fewer cases well than more cases and be rushed through them. The judges all vote in the room as to which cases will be heard. And sometimes they will grant cert, and sometimes they will issue other rulings. Sometimes they have sent the case back to a lower court for further clarification or for more information before they grant cert. Okay, well, let's assume that your case that is so important to you you've been granted cert, and now the judges have requested your attorney write a brief. A brief is a rundown of all the most important, best legal arguments in favor of why you should win. And of course, the opposing side of the case gets to write his or her own brief as well for all legal arguments why that side is correct. They're called briefs, although ironically they tend to be kind of long. In addition, anyone else who's interested in the case can submit a brief on behalf of one side or the other. Frequently, the federal government will issue briefs and these briefs, by the way, if you're not directly involved in the case and you're just offering your legal opinion about the case, it's called an amicus brief. The federal government itself often submits amicus briefs for cases where it feels, well, even though it's not directly involved in the case, it has an opinion on the matter. These are issued by the Solicitor General's office. The Solicitor General is a job in the Justice Department, and he is in charge of being the chief litigator, the person who argues in front of the Supreme Court when the federal government is part of the lawsuit. Okay, well, months after they've granted cert and you have a date to submit your briefs, another date is set for the oral argument. This is where the attorneys go to the actual Supreme Court and argue. It's an hour long. In the good old days, hundreds of years ago, when members of the court and frankly the attorneys had nothing better to do, they would actually argue for hours and hours and hours, sometimes days on end. Famous cases like Dred Scott v. Sanford went on for days. But today we're much more busy, so they stick to an hour limit. That's 30 minutes each side, and they tend to do 4 to 6 per week. At the end of the week, the judges conference again, and this time they vote how they think the case was determined. So each of the 9 judges goes around the table and votes in favor of one side or the other. Based on the merits of the case, they have a chance to talk about the case, why they think one side is correct, why they think the one side won the case. The oral argument itself being 30 minutes each side, one attorney stands up for 30 minutes and is basically peppered with questions from the 9 justices for that entire time period. And the judges love to ask questions to put holes in the weak parts of the attorney's argument. They're trying to kind of pick through what the attorney, why he or she thinks that side should win, and what are the potential consequences. You frequently get a lot of what-if questions. For example, if the court decides in your favor, what impact will this have on X? And you can kind of fill in the blank for that. So you have a lot of hypothetical questions and a lot of questions. Again, they're not asking questions that are easy. They're asking the hard ones to try and get to the really important parts of the case. All right, well, after the conference and they've decided, the Chief Justice decides who is going to actually write the opinion. And there are a few different options. The majority decision, or majority opinion, same thing, is the opinion that the majority of judges agree with. And if the Chief Justice is on that side, if he's one of the votes for that, he will decide who gets to pick, which judge gets to write. And they rotate, basically, among the 9 judges who gets to write the opinions. If there's anyone that dissents, if there's anyone who disagrees with the majority of the court, those are called the dissenting opinion, and another judge will be assigned to do that, to write out that opinion as well. Writing out these opinions usually takes months because all the judges have to agree on every single word in the opinion. And it takes a lot of edit and revision and revision and revision to get the judges all to agree to the exact wording. Because, again, each one of these Supreme Court cases has the potential to be used as precedent for the future. So every single word has very important meaning. There are a lot of things that we do today based on Supreme Court decisions that pivot on 1 or 2 words or phrases. The court's term runs from basically October through June, so you end up with a backlog by June of lots of opinions that have still yet to be finished and completed. So usually about May or so, they stop hearing oral argument and they focus simply on finishing up all of the opinions. And they spend May and pretty much all the way through the end of June writing and issuing opinions. Usually get a lot issued. The last couple weeks of June tend to be full of the most important Supreme Court case decisions for the year because of those usually the ones that take the longest to write.